and Larry in Dallas, Texas. Hey, Larry, what's on your mind?
Hi, Tom. I've been following your show for several years now, and we watch it on Free Speech TV, and we enjoy it, and I've even looked at a couple of your books.
Well, thank you.
And I am...
I have a feeling there's a but coming.
I'm sorry?
Is there a but coming?
No.
But
No,
you're wrong about this. Okay, go ahead.
Okay. Well, I have been a diehard Bernie Sanders supporter, and I was kind of swinging more over towards Jill Stein. But I tell you what, this is the most terrible candidacy in Trump that I've ever seen in my entire life. Yeah. But my question wasn't about that. It was that you were talking about judicial review a minute ago, and I live in Dallas, but I lived and worked in Arlington, worked in D.C. twice during Jimmy Carter's administration and during Bush 41 and during Bill Clinton's administration, and I held policy jobs. Mm-hmm. And you brought up the point about judicial review of statutes or legislation that's passed by Congress. Maybe I misunderstood you, but it sounded like you said you didn't like that idea, that if they were overruling decisions of the states, that's one thing, but if it's a federal law, something else. And I just wanted to give you a little, my perspective is, having been a person that helped write legislation and also promulgate regulations that implement the legislation, I found that legislative review was a good thing. Because sometimes the legislation gets out of line with what the Constitution says, and I'm fearful that could happen again if two branches of government can get control of our government. And then secondly, I know that I work in the Department of Agriculture. The legislation says the Secretary of Agriculture shall prescribe standards consistent with the legislation. Well, that leaves a lot of latitude, which means regulators can promulgate rules that are inconsistent with the intent if they misread it. And so I feel like it's important that we have the three branches of government and the oversight that is associated with it to keep things in line.
Okay. Here's my argument against judicial review. First of all, we survived just fine the first 70 or 80 years as a democracy without judicial review. There were only two cases before the United States Supreme Court between 1787 when the Constitution was 1789 when the Constitution was ratified and the Civil War. Only two cases. The first was Marbury versus Madison in 1803, in which the Supreme Court said we are the final authority on what's legal, and the Judiciary Act of 1797 was not constitutional. And by striking down that law, they caused Thomas Jefferson and James Madison, the president and secretary of state at that time, to win the case. But Jefferson went nuts and said, the court has no right to strike down this case. But he couldn't contend it or contest it because he had just won the case. You can't go back and say, hey, I really want to lose this case. So, but his blowback, and not just his blowback, the blowback from newspapers and politicians all across this country was so large that that it was 2 generations, arguably 3 generations later, before the Supreme Court again invoked judicial review and struck down a federal law, and that was in the case of Dred Scott, and where they or created law essentially, and Dred Scott led us directly to the Civil War. If you look at so when Jefferson was asked he had this very interesting dialogue with Spencer Roane, Patrick Henry's father-in-law, who was I think he was the Chief Justice of the Virginia Supreme Court. He was on that court in any case. Roane wrote him a letter saying, okay, if you don't think that the Supreme Court should be the supreme authority in the land with regard to law in the United States, who should be? Because doesn't the buck have to stop someplace?
Well, I mean,
but let me tell you what Jefferson answered. Jefferson's answer was the people themselves. And the people themselves, by the way, is the title of a book by the dean of the Stanford Law School, Larry Kramer, making the same argument that I'm making right now and that Thomas Jefferson made, which is that if the court becomes the final arbiter, then the court becomes essentially an unelected monarchy. And we do not have a constitutional monarchy in the United States. We don't have and in fact, if you look at the European constitutional monarchies, none of those monarchs any longer have the right to strike down laws or to create law. None of them. And in most of the European countries, their Supreme Court doesn't have the power of judicial review. It's basically, and read the Constitution, Article 3, Section 2 in particular, the Supreme Court is basically the final court for all disputes. But it's not, it is not the court that decides whether the president and the legislature get their say. Jefferson's theory was that if Congress passes laws that are blatantly unconstitutional, that the checks and balances of that is called elections, and that a future Congress will correct that. And we've certainly seen that over the years. I mean, you could argue that slavery was unconstitutional. You could argue that the disenfranchisement of women was unconstitutional. Certainly in retrospect, it has not been courts; it's been legislatures. Well, it was a war too to fix that. And then the other argument against it is even when the court does good things, people say, well, what about Roe v. Wade? If Roe v. Wade hadn't been decided, women wouldn't have the right to an abortion. In 1974, there was a huge movement to legalize abortion in the United States, and several states had already done that. And Roe v. Wade just took it national instantly, which, by short-circuiting the legislative process, poured fuel into the anti-abortion movement so that they could say, oh, we're the aggrieved party. And they're doing that to this day. I would say even when the court does good things using judicial review, the results over the long term can backfire. Back to you, Larry.
I hear what you're saying, and it makes a lot of sense. It's just I have actually seen situations where legislation has kind of gone off the rails. Yeah. And if you only got those two branches of government, sometimes it's helpful to have another arbiter that brings things back around.
But you're talking about an unelected lifetime appointment. I mean, this is as close to monarchy as you can get, Larry. That's the principal part of my level of discomfort. Larry, I'm sorry we're out of time, but it's an interesting conversation.
You're
Thank you.
Listening to the Thom Hartmann Program.
To watch more clips from our programs, hit the Watch More Videos button over here. And please be sure to hit the handy-dandy subscribe button so you'll always be up to date. Tag, you're it.